Hello and welcome to this program. Today we are going to talk about endowment, its meaning, kinds and essentials. So let's start with what is endowment. Literal meaning of the term endow is to provide with property or a permanent income, and endowment means dedication or entrustment of property for some specific purpose. Under the Hindu law, a great emphasis has been placed on dhan for religious and charitable purposes. The people used to donate their property for two reasons: for charity and for a desire to acquire religious merit. For charity, construction of tanks, wells, groves, gift of food, construction of dharmshalas, schools, asylum, place for supplying drinking water, relief for sick, etc. are some main examples. Similarly, to acquire religious merit, the Hindus dedicate their property for the construction and maintenance of temples and consecration of idols, etc. Hindu law recognizes two types of institutions to which the property is generally endowed. They are math or monasteries and temple or devasthanam. There is lack of any separate written treatise on the subject of endowments. Even this is not a part of 18 topics of legal action as listed by Manu. Two main reasons for the scarcity of textual literature are the high moral character of the priests who managed the institution gave less room to disputes. Second, endowments were governed by their own customs and usages having equal binding force as the written texts. The old Hindu law empowered the rulers to supervise over the management of the endowments. Now let us discuss legislations. At present, following legislations are dealing with the subject of endowments. First is the Charitable Endowments Act 1890. It only relates to the charitable but not to the religious endowments. Second is the Charitable and Religious Trusts Act 1920. It covers both the religious endowments into its ambit. Third is the Doctrine of Cyprus Section 92 of the Code of Civil Procedure 1908 establishes this doctrine. It is based on the principle of giving effect to the intention of the testator as far as possible. The expression Cyprus means approximation or as much near to the main purpose as possible. Section 92 provides for instituting a suit for the proper management of an endowment. Fourth is the Charitable Trust Bill 1960, introduced in the Lok Sabha, but unfortunately it lapsed due to the delay in submission of the report on the subject from the Law Commission. The report was later on submitted in 1962, but any comprehensive central legislation is still not passed. Fifth is the state enactments. Several states have passed their own acts over this subject. Example, Bihar Hindu Religious Trusts Act 1950, Bombay Public Trusts Act 1950, Madhya Pradesh Public Trusts Act 1951, Madras Hindu Religious and Charitable Endowments Act 1959, Rajasthan Public Trusts Act 1959, etc. The Supreme Court has defined it as dedication of the property for the purposes of religion or charity, having both the subject and object certain and capable of ascertainment. According to Section 18 of Transfer of Property Act 1882, a public, religious and charitable trust is the one in which the transfer of property is for the benefit of the public in the following matters: relief to the poor, promotion of education, medical relief to the sick, and advancement of any other object of general public utility. Now let us talk about the kinds of endowment. Religious endowments are of two types: public endowments and private endowments. Public endowments means the dedication is for the use or benefit of the public. Beneficial interest is vested in an uncertain and fluctuating body of persons, either public at large or a group of persons of a particular description. The beneficiaries of a public temple are the general public or the members of a particular community to whom the temple belongs. Heirs of the founder have no right to put an end to the dedication. Public endowment cannot be transferred to another by means of gift. The second type is private endowments, which means property is set apart for the worship of the family idol in which the public is not interested. Beneficiaries are definite and ascertained individuals. It is either a particular individual or a particular family. The consensus of all the members of the family may convert a debater property into a secular one. All the members of the family may jointly transfer the endowment with the idol to another family by way of gift. State has no right to interfere in a private temple. Now let's learn something about the essential of a valid endowment. An endowment comes into existence only when some property or fund is dedicated for a religious or charitable purpose or object. Following are the essentials of a valid endowment. First one is the competence of endower or creator of endowment, which means a person should have following qualifications to donate his property for an endowment by a gift, intervisor, or by a testamentary disposition. First qualification is to be major. The endower must have attained the age of majority in accordance with the Indian Majority Act 1875. A minor is incompetent to settle or create a religious or charitable endowment. Second qualification is sound mind. The creator must be of sound mind at the time when he endows the property. Section 12 of the Indian Contract Act 1872 provides that the person making a contract should be capable to understand it and to form a rational judgment as to its effects upon his interests. Third is the right to donate the property. The person must have right to gift his property either inter vivo or by will. He should not suffer from any legal disqualification. Apart from this, two other disabilities under the old Hindu law are corpuscular's disability in respect of his interest in the corpusculary property and woman's disability in respect of woman's limited estate. This was all about the first essential. The second essential of endowment is subject matter must be specific and ascertainable. Subject matter of the endowment, that is, the property which is to be utilized for the purpose of endowment, must be specific, certain, definite, and unambiguous. It is ascertained when it is separated from the other properties of the settlor, so that it may be known without ambiguity. Third essential is object or purpose of endowment must be definite or certain. The object or purpose must be clearly mentioned. By certainty means that there should be no possibility for any kind of controversy or division of opinion about the purpose for which property is dedicated. The fourth essential is the object must be either religious or charitable or both. Religious purposes are those which are related to the other world or the relation between man and the God. For example, worship of family deity, performance of shraddh of ancestors, propagation of dharma, for shelter of sadhus, saints, etc. Fifth essential is dedication must be complete. Complete dedication of the property is essential for the creation of an endowment. It consists of two elements: sankalp, formula of resolve or intention to dedicate property, and utsarg, renunciation. The ceremonies of dedication begins with the sankalp, that is, intention of dedication, followed by the recitation of time, date, year of dedication and of the object of dedication. Then utsarg completes the gift. It implies renunciation of the ownership by the giver in the property given. In the modern Hindu law, dedication is complete as soon as it is established that the founder intended to make a gift in favor of a charity and that he had divested himself of the ownership of the property. Sixth essential is, not in contravention of any legal provision, the creator must dedicate his property in accordance with the relevant provision of law. For example, if any person intends to endow his property by his will, he must comply with the requirements of making a will as per Section 57 of the Indian Succession Act 1925. It means that the endowment must be in writing and attested by at least 2 witnesses and signed by the author of the endowment. The Hindu system recognizes 2 types of religious institutions: mats or monasteries and temple or devasthanams. Now let's know what are these mats or monasteries. Mats or monasteries are the places whose main purpose is to spread the religious knowledge through instruction to the disciples and the followers of the mat. It is also known as astha, which means abode or residence of ascetics. This monastic institution is presided over by its head known as Mahant. In Krishna Singh versus Mathura Iyer case, the apex court observed that a mat is an institutional sanctum presided over by a superior who combines in himself the dual office, first of being the religious or spiritual head of the particular cult or religious fraternity, and of the manager of the secular properties of the institution of the mat. Now let's discuss the basic purpose or object of mats: to study and propagate the religious or philosophical tenets of a particular school or sect, and also to maintain the line of its gurus and scholars. It is also a place of residence of the teachers and the students who teaches or learn the doctrines of the sect or cult to which the mat belongs. Now you would be wondering how mats came into existence. A mat comes into existence when some property is dedicated to it. The endowed property vests in the mat itself as a juristic person, and the mat is capable of acquiring, holding and vindicating legal rights through the medium of some human agency, which is ordinarily the Mahant. He is the head of the mat. He manages all the activities at the mat and also manages its properties. Now let's talk about the kinds of mat. There are several types of mats and each of them is governed by its own custom and usages. This categorization is based on the mode of succession it follows. First one is Marushi mat. In this kind of mat, the office of Mahant is elective. The reigning Mahanto nimtis a successor to his seat from among his disciples. This kind of devolution from Guru to Chela is known as hereditary succession, but it is not succession from generation to generation in the same family, as the Mahant is a sannyasi who has renounced worldly affairs and severed his ties with his family. If a Mahant dies without having nominated his succession, then a religious society constituted to make arrangements for the appointment of Mahants may provide for the appointment to the vacant post of the Mahant. Second type of Math is Hakimi Math. Here the founder has reserved the power of nomination of Mahant. The successor is appointed in accordance with the rules laid down by the founder. Third is the Panchayati Math. The successor is elected by the members, ascetics of that Math. The right of succession devolves on all the disciples. Normally, the senior-most disciple is nominated unless he is found to be unfit for the office. If the Math is one in the chain of a number of Maths of a sect, its Mahant may be elected by the Mahants of the other Maths. These days, the state is exercising in the public interest control over the religious and charitable endowments also. It may provide legislation for this purpose. Now let's talk about office of Mahant. Mahant or Madhadipati or Swami or Pithadipati is the head of a Math and the religious and spiritual guru or teacher. His duty is to practice and propagate the religious tenets of his Math. He is also the temporal head of Math who looks after its secular management. Now we will talk about the qualifications for appointment of Mahant. A Mahant must be a man of learning and character. Section 53(2) of the Andhra Pradesh Charitable and Hindu Religious Institutions and Endowments Act 1987 has laid down the qualifications required for a Mahant. Basic knowledge of the Hindu religion and philosophy, knowledge of the relevant scriptures of the sect of the Math, capacity to impart the knowledge and preach the tenets of the Math to the disciples, religious temperament with implicit faith in discipline and practice, and unquestionable moral character. Now let us discuss powers and obligations of Mahant. The position of Mahant is a blend of office and proprietary rights, of duties and powers, etc., which cannot be detached from the other. He has dual capacity as manager of property and spiritual head of the Math. Obligations and duties of a Mahant are governed by custom and usage of the particular Math. He is neither a trustee nor a corporate soul. He is like the manager of the Math with wider powers than those possessed by manager, trustee or dharmakarta of a temple. Following are his powers and obligations. Management of Math and its properties. Mahant holds properties of Math and manages them in accordance with the specific purposes laid down by the founder of it. In this regard, duties of Mahant are upkeep of the Math, performance of religious rites, ceremonies and festivals of the religious order to which Math belongs, to support his disciples and other members which constitute a sort of household of the Math, to make arrangement for food, stay and like things for the visiting ascetics. Second one is the power to use funds of the Math. Mahant has a large power over the income of the endowed properties. He has discretion in application of the funds of Math, but subject to certain obligations and duties equally governed by custom and usage. Third is the right of representation. Mahant occupies a representative capacity having right to institute a suit on the behalf of Math and duty to defend the suit instituted against the Math. It is Mahant who represents the Math in all its dealings with the outside world. Mahant's fourth power is to borrow money. For the purpose connected with the Math, he may borrow money. he has power to bind the endowed property by his debts taken for justifying necessity. Fifth is the power of alienation. He has power to dispose of the properties of Mat for legal necessity or for benefit of Mat properties. But he has no power to alienate property except in case of need or for the benefit of the estate. Sixth power is that Mahant is liable for accounts. He enjoys almost unfettered powers over the income of the endowed properties. Out of this income, he has to discharge all obligations connected with the purpose of endowment as laid down in the deed or by the custom or usage. He occupies a fiduciary position and therefore he should keep proper accounts. The failure to keep accounts may be a ground for his removal. So this was all about Mats and Mahants. Now it's time to talk about temple or devasthanams. Temple or devasthanams are places of worship where an idol is instituted as the image of the supreme god. The property of an idol is known as devotar or dibatar. An endowment for a temple or an idol may come into existence by establishment of deity or by consecration of the idol, or before the consecration of the idol. Sometimes the idol is constructed or purchased with the help of its own devoter property. When the property is dedicated to an idol, it vests in the idol itself as a juristic person. The institutions endowed to God are managed through human agency. The Shibet is the human agent to manage the property of the idol. Shibet means one who renders services. Usually at the time of establishment of endowment, the founder appoints a Shibet or himself becomes a Shibet. Now let's discuss position of Shibet. A Shibet is a person who is a mere manager of the Batar property. In a broad sense, he is like a manager. Regarding the endowed properties, he is more like a trustee as regards his functions and duties towards the temple in spiritual sense. He is a holder of an office of dignity. Although his rights and duties to some extent resemble those of a trustee, he is not a trustee in the true legal sense of the term, in as much as the property of the temple is not invested in him. Shibetship includes two things. First, the manager or administrator of the properties attached to the temple. Second, the servant of the duty. Now, powers and obligations of Shibet. The rights, powers and obligations of Shibet depends upon three factors. First, the discretion of the founder. Second, in absence of the founder's discretion, the custom and the usage of the endowment. And third, in absence of the above two, the general Hindu law relating to the endowment. Now, power of Shibet. First, custody of idol belongs to him. He must perform seva and puja of the idol. Second, possession and management of the devoter property lies with him. Since he is like a trustee, he cannot make profit out of the properties for his own private or personal use. Offerings made to the idol of permanent character belong to the temple, and the one of perishable nature belong to Shibet. Third is the right of residence. He has right of residence in the temple property unless expressly prohibited in the deed of endowment. It is necessary for the discharge of his duties of supervision, etc., towards the idol and its properties. Fourth is the right of remuneration. Generally, he has no right to get salary for his services. But if the deed of the endowment or the custom or usage give him some remuneration, it is not opposed to the Hindu law of endowments. Fifth is the power to file a suit to challenge any transaction for the benefit of idol or devoter. He also has the right to defend it on the behalf of the idol. Sixth is the power to borrow money. He can borrow money by loan or on some security if necessary for the benefit or preservation of the property. Last one is the power to alienate endowed property. Generally, it cannot be alienated by the shibeth, but he can do so for necessity or benefit of the property itself. Broadly speaking, he can alienate the property only for the need of the idol or for the benefit of the property itself. Now let us discuss what are the obligations or duties of shibeth. To keep accounts of property, to discharge duties personally, for example, to perform seva and puja, not to purchase devoter, safe custody of deity or idol, not to embezzle property, bound to do whatever is necessary for the benefit or preservation of the debater properties, and duty not to delegate his functions. Now at last we are going to talk about removal and replacement of idol. An idol is worshipped as an image of the Supreme God. Generally, it cannot be removed from its permanent place, but in some extreme circumstances, the removal of the idol is permitted. It may be removed for the purpose of the construction of a new temple. Temporary removal is permissible in case of necessity, for example, flood or earthquake or any other contingency. A new idol can be replaced for the old one if it is destroyed or burnt or broken. Sometimes there is a need of reconsecration of the idol if idol falls from its place or removed from its place or touched by an animal or the hymns prescribed for the another deity are recited before it. In these cases, it is believed that the deity has left the idol and it returns with the purification and consecration of the idol again. So that was all for today. Hope you have understood all about endowment. See you soon in next program with a new topic. Till then, take care of yourself. Goodbye.